A new Trump administration policy is ringing alarm bells for immigrants applying for green cards through family ties effective immediately. Those without legal status who apply for residency through a spouse or other relatives could face deportation under the new guidance from U.S. Citizenship and Immigration Services. Let's take a closer look at the story. We're joined by immigration lawyer Kripa Upadhyay. For more, Kripa, thank you for coming on here on Washington Watch. Kripa, so how exactly would this work? I'm just wondering, so if, say, there is an American citizen applying for a visa for her husband who is in the US illegally for whatever reason, say overstaying a tourist visa, then the husband could be deported.
Yes. And again, this goes back to this administration's extreme focus on the enforcement component. So we're seeing a couple of things, Allister. One of the things that we are seeing is any period of overstay is something that they are prosecuting to the fullest extent that they can. Historically, if you had entered the United States on a tourist visa or any other visa and had overstayed, but are married to a US citizen, you would have been allowed to at least appear for an interview and complete the process in the US. Right now, if the marriage, for whatever reason, was determined to be fraudulent or lacking sufficient documentation to show that it was a valid marriage, then at that point you would face a denial of the underlying application, and that would then potentially put you into removal proceedings. However, what we are seeing now is individuals that are in process, called for an interview, are being arrested at the interview itself.
Is there any way to get out of this without having to face that deportation in that case?
No. No, the only way that you could file for an adjustment of status is via the U.S. Citizenship and Immigration Services, right? And so what you're essentially doing at this point, if you are undocumented in the country, is waving a flag, if you will, saying, you know, here I am, and then essentially making an affirmative election to face the consequences of having to go in for an interview and the perspective of being arrested at that interview and placed in removal proceedings. This also then dovetails into alternate proposals that have come in because of alleged backlogs in the court system, right? So the immigration court system is enormously backlogged, and that's, again, contributing to that, because the more people entering immigration removal proceedings, we already have a backlog of about 3 million from last year. We're just adding more numbers to that. So if you have a citizen that is married to a non-citizen that is seeking adjustment of status in the US, if USCIS makes the decision to deny relief to that person, it's now up to the immigration courts. But the immigration courts process is already backlogged something like 5 to 7 years right now for a final adjudication on the merits. Right, so it's an absolute snowball of consequences.
Attorney joining us here on Seattle. Thank you so very much for your time. Got to leave it there. Sorry, running out of time here on the show.